Good afternoon, Patriots, and welcome to the 67th audio chat on the Q News Patriot Rumble channel series. I am the Q News Patriot, joined with you today with We the People Network, Tom and Doug. My name is SG Anon. Along in this journey of the Great Awakening, one of the more esoteric concepts is law and justice and the execution and administration of law underneath the sovereignty of God. We, the people, are God's agents of the law and of order and beauty here in the world. We were given regency according to the good book. And as we work our way back towards that and get out from a corporate maritime fiction masquerading as our lawful government, we have to acknowledge that a spirited debate and understanding exactly what we're doing are both necessary to progress our civilization forward. Doug and Tom have thousands of hours into this particular topic. Their opinion, I think, holds significant weight, and I'm glad to have them on the show today. Thank you, gentlemen, for joining me.
Thank you for having us.
Absolutely.
Well, it's the honor is really mine, and we've connected it once before, I think, on this particular topic, but I am just very curious for my audience, and since you all are meeting the audience for the first time, do you care to give us, without waxing, too poetic here, a little bit of a good background on how you both came to the common law understandings that you have and what that research basis has looked like?
Sure. If you don't mind, I'll start off, Tom and SG. First, I want to say thank you for having us on your platform. We enjoyed when you came on We the People Network. It was very popular, and we're very grateful for your time. My co-host, Ed Dolezal, who you met on that platform, is away, so I invited my friend and patriot, Tom Sykes, to join us today. Tom's one of our WTPN weekly common law trainers, as we do a weekly common law free training on our platform, or at least through Telegram if we don't get it videotaped. And he's the moderator for the General Drill Assembly in Sarasota, Florida. So I just wanted to let everybody know who Tom was. And We the People Network, predominantly what we do is we do education for common law and the proper way to restore, not reform, our Republican form of government. And so that's kind of who we are, a little about us. And so I just wanted to say that if I could. Tom, do you want to talk a little bit how you got involved?
Well, I moved to Florida in 2017. I moved from Virginia. I retired from my job in transportation, and I was also an elected county supervisor in Virginia for Augusta County for 12 years. So when I moved to Florida, I decided that I was going to quit politics and come live in paradise. And that didn't last too long. When 2020 came along, I just felt internally that there was something wrong and I had to do something. So I started digging and digging and digging, and I started with the issue with children. And when I first heard the sum of 800,000 children going missing in this country a year, I just couldn't believe it. So when I started digging and I found out more truth coming forward, and then we saw the top characters of CNN being erased and eliminated for pedophile, it started connecting. And so I got into it. And then when I met some people that were talking about common law, and it just gelled with me. And when I started really studying the Constitution and comparing it to where we are in today's world, it was almost like a Peter Pan book. It was a fantasy, because so many people have disrespected and disregarded our Constitution. So it's time for us to stand up and take it back. So that's where I am today.
That's powerful. And I'm sorry, sir. Please continue.
No, that's okay. I'm sorry, SG. I didn't really answer your question. I kind of just talked about who we are, but my brief story is right around when the COVID nonsense started and our lockdown. I just started praying because I was looking for something to do, and I knew that I didn't really want to be on a board, a school board, and I really didn't want to run for office. It wasn't something I wanted to do, but I was praying and praying and asking God, what should I do? What can I do to participate in this fight? And I looked at a lot of different options out there. There's many options out there of restoration that people are offering, and my spirit just wasn't right with a lot of them. I ended up at a group gathering for a General Assembly, and it resonated with me because it's based on the First Amendment and constitutionally in our founding fathers. So long and the short of it is I just prayed and I said, God, this is it. Until you tell me to stop, I'm going to do this. And within a couple of weeks, I was writing and writing and writing documents and researching and doing everything I could. And I got invited on a platform, Patriots with Grit, these really good guys. And that kind of just launched it for me. And I really didn't know a lot when I was starting on there, but it was a divine intervention and it worked out great. And so then God called me to do a platform. And the idea of the platform was to invite patriots that didn't have a voice to come on and have a voice. That was originally the idea of it. And we still do something called Patriot Profile, where patriots can come on and do a profile if they have something to say, but don't have a platform to say it. And then it's just grown from there. But that's the calling I have. Until God tells me to stop, I'm going to stop doing it. And got very involved with the assemblies, building their websites. We're writing a manual now for every assembly, and there's many of them around the country, over 30 states now that are assembling. So that's my story. But thank you for asking.
You know, if I may, one of the coolest things in this journey is getting to hear how everyone was sort of activated at a soul level by the things that they saw transpiring around them. And there has been this deep awakening in the souls of humanity all across our great United States and really most of what you would consider the developed world, the global north, to reclaim what it means to be liberty focused and to be autonomy minded and to run our governments and our communities in a proper balance with one another. And so that leads me sort of into my first question for the broader discussion today, which is how the community needs to look on the other side of this. We have a number of different approaches that are being taken. A lot of different lenses are coming out there into the public space now surrounding common law, surrounding authority. Where does authority derive from? What is the proper interpretation of some of the plain text Constitution for the Republic pre-U.S. Civil War? So I'm going to ask sort of a loaded question, and you know, you gentlemen feel free to answer however you'd like to, however you are comfortable with. But what should our communities at a common law orientation look like on the other side?
Well, if I may, I'm sure Tom has something to say about that. I think it's important, SG. Well, right now, I believe the door has been left open for the restoration of our true republic as the founding fathers have established it. And it can only be done through our general jural assemblies. And I think it's important when we look at that and we say, well, what's the relevance of that? And how is that going to resonate with the people that hear it? Is to look at history. And if you allow me to belabor through history a little bit, I think it'll take us right up to where we are with the assembly. And then I'm sure Tom can add a lot to that because he's super active in doing the work that needs to be done. So on March 4th in March 4th, 1861, Abraham Lincoln became president. And 10 days after, he virtually pissed off the South and they walked out of Congress. And those that remained did not have a quorum, so they could not adjourn that meeting. And technically, the meeting is still going on today. In 63, 2 years later, 1863, Lincoln issued a General Order 100, which put us under the Labor Code. So I'm sure you know all this history, SG. And that's technically military law, martial law, until the people return to their office. Well, 10 years later, 1871, or 8 years from then, the people never returned. So the military hires the Virginia Company, owned by the king, to act in our offices until we reassemble our republic and reelect our interim de jure representatives to those offices. Thereafter, the Act of 1871 was enacted, which is also called the District of Columbia Act of 1871, which is an act that repealed the individual charters of the cities of Washington and Georgetown, and they established a new territorial government for the whole District of Columbia. Thus, the de facto corporation, as we know it, was born. And technically, every law or everything that's been established since then that's been directed at we the people is really unlawful. And so we go on. In 1928, people still did not assemble. So the War Department introduced a field training manual, number 2025, on citizenship and how to return to a republic form of democracy. Actually, it was how to return to a Republican form of government. from a democracy, excuse me. As I understand it, in 1932, FDR, on day one of his presidency, put into play an executive order to destroy the Field Manual 2025, and along with it, all the documents that were negative to a democracy. So most people do not know this, but again, as I understand it, General Douglas MacArthur joined the military prior to the manual being destroyed. And years later, when he was commander of the Pacific Fleet, he handpicked a select group of people and drilled them in constitutional and common law and nation building. One of these people's name was a gentleman named Carl Miller. Together, they formed the original Restore America plan. There's been others since, but at the time, people were not ready for it, but I believe they are now. And so to move forward, JFK brought forward Executive Order 11110, putting us back on the gold standard to retain the judicial system and common law. He had a warehouse of literature to be mailed out to the American people. 3 days before the literature is going out, they assassinated him in Dallas. So needless to say, the literature never went out. Ronald Reagan tried to pick up where JFK left off, and they shot him. 2008, Obama comes into office, and the shit show continues against We the People. So Carl Miller, to bring us up and to finish this, Carl Miller, who again was a student under MacArthur, together with other patriots in and around 2010, formed the Michigan General Jural Assembly. And now many other counties and states are following their template. The problem is the deep state has set in play a divide and conquer counterattack, where there are many alternative deep state funded organizations making republic restoration promises, really without proper remedy, and people are getting hurt. They know, unity is essential, and of course they seek to divide us. So here at WTPN, we're on a mission to speak truth and give clarity to the people and to teach proper remedy and common law. And that's kind of where we are up today. Thank you for belaboring that long history, but I think it's important that people see where we lost it and where we've come to and what the proper remedy is. And now, right now, Michigan is a nation state, which means they're recognized by 8 countries in the world. And there's others as well. Alaska and Missouri are already established as a nation state. So Tom, I defer to you or to SG. Thank you.
All right. Thank you, Doug. In Sarasota, we studied significantly for 3 years. And then in April of 23, last year, we put together a seminar on training people about self-government and what common law required, what the 3 elements of the assembly were, the assembly, the grand jury, and the militia. And so we started teaching these classes in different locations within Sarasota County, because we've got 500,000 people here, and it's a large county, and it's a lot of diverse sections of the county. So we wanted to open up and attract as many people as we could. And after the 4 weeks of training, we put out a call to assemble. In April of last year, we were fortunate to have nearly 30 people show up for that meeting to form the assembly. And in 2 weeks later, after that, we went ahead and formed our common law grand jury here in Sarasota as well. And we have members from 3 counties, from Manatee, Sarasota, and Charlotte County are members of the grand jury. That qualifies us to be a statewide grand jury, and we can go into any area within the borders of Florida. And when we started looking at what the assembly was going to do in Sarasota, first of all, we wanted to get a good analysis of where we were with our elected people. So our First Amendment rights says we have the right to redress a grievance with our public officials. So what we started doing was sending out petitions for redress of grievance, and we call those PFROGs, but we sent out a petition to every elected person within Sarasota County. Now we've got 4 municipalities, so we sent it to those individuals as well. So we've got 59 elected people here in Sarasota, and we wanted to look at just the baseline. We wanted to have a copy of their oaths, their bonds, their unencumbered property, what they considered was their basically a flow chart of their organization. And so these were basic questions, and several of the groups responded, but several of the facilities and municipalities refused to even answer. So we have proceeded forward, and we have given them multiple notices, and now we've put them into what we consider a default notice, because we've given them 10 days between each notice. So we've given them 33 notices. And so the final notice was a 4th notice. So we spent over 40 days notifying these people of what they need to do. And being here in Florida, I am really shocked at the lack of knowledge that our elected people have regarding their own statutes. Now, we know the 3 Supreme Court cases that have declared statutes, ordinances, codes, rules, all of these things are for employees of government only, and if you live in DC. But these statutes do not apply to we, the free people of this country. So we have been bamboozled, we have been snookered, we've been cheated to believe that all of these statutes that are originally only for government people, they're applying to us into their corporate court situation, which, as you mentioned in the Act of 1871, every state, every county in this country was incorporated. So including the court system. And I've got the DUNS number for the Florida court system. If anybody wants it, I can share it with them, or you can go to Dun and Bradstreet and look it up for yourself. But all of our courts in Florida are corporations and not where justice is served. So we now have started digging through the Constitution and each office, and we have gone through the county charter. If people would remember and look up this in your own version of your Constitution, but Article 4, Section 4 of the U.S. Constitution states very clearly that the United States guarantees every state in the Union a Republican form of the government. And when I started pulling the charters for the county and the different operations, all of these counties and the hospital and the charter review boards are declaring themselves body corporates because they're in charter. So, I mean, it's right in front of us, and they still don't recognize what the problems that we're dealing with. But the legislature has made some changes. The counties across the state of Florida have interpreted those regulations to their own benefits. There were actions where people that were elected needed to provide a performance bond. And in 1998, the legislature in Florida decided that county commissioners could decide whether their county officers need a bond or not. And in Sarasota, we've got the people in assessor's office, the tax collector's office, the hospital treasury, all the hospital secretaries. All of these people are handling in Sarasota in excess of $1 billion a year in public funds, and they decided they didn't need a bond because in the statutes, Florida statutes, it says when an officer is required to have a bond, he's also required to establish and post unencumbered property that they own to substantiate that bond if it's ever called. So not only did they do away with requiring themselves to have a performance bond to protect we, the people, they're not even posting their own property in case they're required to do this. Now, we're talking about statutes. We haven't even started pushing into where they are in violation of the Constitution. And let me speak just a minute on what is the objective of an assembly. An assembly is to protect the people's rights that live in the county. And it is to notice any public official when they step out of bounds of the Constitution or when they create harm against one of our neighbors. And we are to notice them and keep them in touch and to audit and look at their efforts. And actually, we're going to be putting out report cards on exactly how they're performing in their constitutional duties. So we're a year into it. We have got every one of our officials in Sarasota County in default because of their lack of response. Or if you're talking about Florida counties, you really need to look at the oath that the state has put into the systems for people to give when they're elected to office. The statute says you must give an oath. Well, they've changed the words in our oath. They are giving praise and allegiance to the Constitution of the United States, which is the corporate model in DC, and they've added the words "and government." And ladies and gentlemen, if I can convince you of one thing, we the people are the government. And when we did not delegate any specific authority, our forefathers in the Constitution, then that responsibility is retained in full by we the people, such as running elections. There is no delegated authority for a supervisor of elections. The elections are supposed to be run by we the people. We select the candidates. We run the elections. We count the ballots, paper ballots, in one day. And then when it's over, we tell the government who won. It's not handled by the government. So that's just one issue. And then our public hospital that we have here it's just everybody has taken the opportunity to trash the Constitution for their own personal gain. So we're just fighting back.
And a powerful mission, I think, that we are currently waging. And I commend you on the ground there in Sarasota for your efforts. It is refreshing and wonderful to hear. And that leads me sort of into my next question. And this, again, lobbied out there for both of you gentlemen, and that is the reclamation and the recapturing of our appropriate judiciary. We need a judicial form of government that represents and dispenses law and order. And we understand this, what we would call law and justice under a common law system. It's required, I think, for the social compact and the ability to self-govern and to live our lives to the fullest extent, but in a team and community sense with one another. And yet we're faced right now with a highly captured judiciary. It's actually captured enough that it seems very daunting in some regards. What is the remedy that you gentlemen have been employing and been observing? And do we have any historic examples we could draw from, particularly any that predate 1871?
Tom, if I can, I'm just going to start briefly and I'll let you roll because I know you're just chomping at the bit on this one. SG, it's so far beyond the understanding, comprehension that people have. It's every court system in the country, for the average person is under a maritime system. And you know this. And the maritime system is not, it really doesn't affect we the people. That's a corporate to corporate entity. When we step into their jurisdiction, we have to many times because we've opted into their system. It starts from our parents entering our birth certificate and then putting us in capital letters and incorporating us with a bond. And then it steps into our driver's license. We've opted into the system, our registration, our marriage certificates, our business licenses, and goes on and on and on because we keep opting into their system and into their jurisdiction in their courts. They really have no jurisdiction over sovereign men and women. And so the result or the solution for this, as the founding father gave us, was the grand jury, the proper grand jury. And I would like to defer to my associate, Tom, and he can talk to you a little bit about that. Tom?
The grand jury, running all the way back to the Magna Carta, where it stated that 25 barons of the community were pulled together, with 4 of them being investigators, and these 25 barons would hear the cases that comes before them. Now, a common law grand jury does not decide guilt or innocence, but what a common law grand jury does, they have 3 decisions that they can make. First, if there's not enough evidence to even consider the case at hand, then the grand jury can present a no bill. They can pass a no bill. Or if there's evidence that there is a crime or there's a problem going on, but there's not really a complete convincing evidence, the grand jury can do what is called a presentment. And that's where they can write the case up with the penalties if it's true and send it to the accused individual. And that gives them 40 days to respond that they are innocent. If they have excuses, or if they have alibis, or if the charges were of a different person, any type of recourse that the accused has, he has 40 days to send it back to the grand jury. If that person does not respond in 40 days, on the 41st day, they become automatically guilty through their acquiesce, and then the grand jury can then file the case with a magistrate to move forward because they're guilty. Now, the grand jury, if they have evidence in hand and their investigators have presented enough evidence that the grand jury can determine, yes, a crime was committed, a fault was committed, a trespass was committed, there is enough evidence, then the grand jury can produce an indictment that is ready to go to a petite jury. Now, the next step would be a petite jury. It's a common law petite jury, which is made up of 13 people, 12 jurors and 1 for an alternate, of the persons accused of the crime of his peers. This doesn't mean that we select people out of a jury pool, out of people that doesn't know the accused from Adam. The whole thing about common law is treating people with respect and honor. And what the term peers means when our fathers wrote this is the fact that these people know you. These people know about you. They know your character. They know you living in the neighborhood, the communities. If you're an upstanding person, they're going to know this. And they will take all of this into consideration because a petite jury decides the outcome of the trial, and they can actually nullify any law that they deem present that it's not applicable for this case. Now, what does that mean? So that means if a person is caught up in a situation where it was not an intent, it was an act, whether it was an accident or an unintended condition that occurred, the jury can take in all of that information and make a consideration, and they can actually say, no, this law does not apply at this point. So the petite jury in a common law grand jury system can nullify a law. Now, the very important thing to realize, and our forefathers realized the corruption in the court system with the king controlling his judges. And so a petite jury is controlled and managed by the foreman of the jury, not a judge. A judge is not in the room, nor a prosecuting attorney. So there is no conflicting jury tampering. There's no instructions to the jury. And the biggest thing that we need to do is realize that in the statute system now, they have what is called a jury trial. And the difference between a trial by jury in common law is a trial by jury is of your peers, and it is handled by a petite jury. In the statute system, these guys are making the rules up as they go along. They'll pull 6 jurors in and say that's your trial by jury. And then the judge will instruct them how to operate. The prosecuting attorney will tell them what decisions they need to make when they're addressing the jury. And so it's all a hoax.
Yep.
It's all designed to take money and people away from people and to keep them in prison and keep us enslaved under debt.
So may I as you asked, how do we actually create this system and when the other system is in existence? Well, it's done through the development creation of our grand juries locally, of our We the People grand juries. And that involves one major thing, education, because if you're going to try to put it together a jury of your peers have to be knowledgeable on common law, and they have to be knowledgeable about how to actually investigate and administrate that law. And so it's very important. We do trainings every week, particularly on this, on how to teach people how to, think through just the facts, not emotion or prejudice or anything. What are the facts? And we do a lot of object studies and examples on how to teach people to start thinking that way. But the biggest challenge we have is just this: is education, educating the people on their sovereignty, their common law, this understanding that the systems and the jurisdiction they're under is not sovereign, and that they can stand up their own grand juries, and they do have a way of coming against this in a lawful remedy. So I just wanted to add that in because we kind of went around your question a little bit. So,
well, in the current court systems, being corporations, when you walk through the gate, basically you pass the bar going into the court system. When you are in that court system, you are standing in front of an administrator of a corporation. And when you claim you have constitutional rights, that then becomes a comedy for them because they know you have no constitutional rights standing in the middle of a corporate meeting. It's the same thing as you walking into Walmart and said, I think you need to change the color of your logo. I don't like it. They're going to pay as much attention to you there as a judge will, saying you have rights. I yield.
Our discussion is simply enthralling, and I'm very much enjoying the historic context behind this because it is fundamental to understanding how our republic was silently overthrown. That was the only logical way that could ever have been accomplished in light of our Second Amendment here in the United States. And it really, if it wasn't so colossally evil, it would be very impressive and sort of noteworthy. And so that leads me into another question here, which is, surrounding the common law grand juries and the idea of the grand jury being a separate form of government entirely embodied within We the People. I believe there was a Supreme Court decision even on this topic, U.S. versus Williams, and if I'm not mistaken, it was Justice Scalia who wrote the majority opinion. I'm not a legal scholar, and to try and break it down on my end, I think I would end up waxing a little too long here. So would you gentlemen please give me a rundown on how that is significant to the discussion today?
Yes, I'll take that a little bit, if you don't mind, Jug. Justice Scalia came out and very clearly and plainly made the statement that the common law grand jury, the petite jury, when they make a decision, it is final. A petite jury can never be challenged. It can never be overturned. It can never be overruled, because he made the most important statement of that ruling is the fact that we, the people, are the highest level of government, and our petite juries are highest jurisdiction of any court. It's basically the 4th level of justice in this country, and a common law grand jury decision sits above a Supreme Court decision. I yield.
Yeah, one other thing that I believe was stated in that decision was that there was establishment that common law dockets have to be allowed in courts now. This was a huge thing for the people, because now they have to recognize to some degree that there is common law, and it is established. Unfortunately, we're still in their jurisdiction. So, you know, the moment you walk in a boardroom, a local, you know, community board, or you walk into a public building, or you walk into a courthouse, you're already in their jurisdiction once you walk into their building. So it's not even like you can go there knowing what to talk about, because they've already got you bound. But it's important to know that that was a very important decision, and it's a foundation for the things that we do.
And if I'm understanding this correctly, gentlemen, throughout this process, given that we do have Supreme Court sort of assent to this topic, we have a pretty, plain text basis once we truly get into the research for what a lot of this really looks like and what a great deal of it looked like pre-U.S. Civil War. That alone would be an entire show on itself. It seems to me that the issue that we're running into is law enforcement itself, in the sense that we, the people, are able to convene these groups and to issue authoritative statements and to evaluate evidence critically, analytically, honestly, with integrity. We do need those that carry those decisions and those actions out. And it seems like we've had co-opting in our officers of the peace, what we would call, the sheriffs of the days of old, who were the elected officials, I think, representative of the people in that sort of the other side of that common law grand jury coin. If you all don't care, can you give me a rundown on what is actually at play with this and why have we run into this particular obstacle?
Doug, I'll take off on that as well. And
Yeah, no problem. That's
the
why I have you here, Tom, to make me look good.
the issue with sheriffs, the design of a sheriff is supposed to be the highest constitutional officer in any county. And what we have, we've got a little over 3,400 counties in the United States. And my last word that I heard was there's something less than 200 of these 34 counties actually occupied by a constitutional sheriff, because the court system is demanding that the sheriffs provide services to them, and the sheriffs are working in coercion with the courts to continue to take money. The Fifth Amendment clearly states that in order to have you accused of a crime, there must be a presentment or an indictment from a grand jury. How many arrests are occurring today when they say, well, we'll just go by and get a warrant from a judge? You haven't had any of the processes that our Constitution calls for. Following the law, following the just law, following the rule of law, these guys have coerced it. They have changed it to their own agendas. And when you go into the court systems and you go through the sheriff's department, you have to understand, and I'll touch briefly on it, but again, this could be a topic of a completely different show, but your birth certificate accounts are being charged by these court systems when you go through there and you don't even know it. So it's a money-making scheme. There is no delegated authority for these codes to be charged to the citizens. And when you have a sheriff's department that is working in conjunction with the other county officials, such as Child Protective Services, and they're taking these children out of families, they're taking people out of families, they're taking and arresting people without the due process of law, that's where we run into a problem. We will not be able to clean this up clearly until we have military law intervention and we get this recognized at the sheriff's level. I yield.
Yeah, as you know, if I can add, SG, you understand this is such a massive magnitude of de facto system. The American Bar Association are unregistered foreign agents, and you've got the bar, and most of our congressmen, all of them are bar members. And then it stems down to the sheriffs. We have interviewed so many sheriffs, and virtually none of them understand anything about common law, and they hold so much power. Now there are agencies out there that are trying to educate them, but not all of them have the full common law accurately as well. So that's a problem. But it stems down and trickles down to the police officers, who most of them are good intentions, but they don't understand their oath either. And their oath is to serve we the people. And they have become, virtual, law enforcement for the upper strong arm hand of the illegal de facto system. And so they're just doing what they're told. Most of them don't know what they're doing. They don't know any better. And so we have a really bad situation. And, it is going to take a real major change. But what's important to know, the change is coming. And what we have to do as a people is we have to stand up our assemblies, we have to stand over grand juries, and we have to educate ourselves in the system of self-governance, because there will be a time coming soon, God willing, where we are going to have to stand up our local governments. We've been told that the government, then the state, then the county, and we've talked about this before with you and others, is how the hierarchy goes, but it doesn't. All the power is with the people in the county. It used to be in the townships, even smaller, many years ago, because they came together and worked out. There is no harm in common law. If there's no harm, there's no injury, no harm. All you need to do is make restitution, and otherwise there's no crime. So it stems down from the hierarchy of the sheriffs through the law system, through the officers. So I don't want to belabor it, but that's important for people to understand on a basic level.
Indeed, it is. Perhaps one of the more important facets of understanding along in this journey. We have to return to a system that is oriented towards fairness, honesty, and justice with one another, and considers, of course, the common law aspects of mercy, compassion, and intentionality into the mix. I think if we remove those from the mixture, we're left with something that is very dead-like. And it's fitting then that the word corporate actually describes a dead entity. Doug, Tom, for those out there that would like to learn a little bit more or connect with We the People Network or some of these learning sessions, where can Patriots find you?
Well, if I may, Tom?
Yes.
Our website is WTPNlive.com, and we'll also have our podcast, We the People Network, on Rumble. I just want to say that We the People Network is part of the We the People initiative, and it's important to understand that this is a real-time political exercise, both top-down and bottom-up. Regardless of who's in the presidency, our mission remains the same, and that's to regain control of our communities and restore our Republican form of government from the bottom up. And by doing so, assemble our states and take back our republic for which it stands. So for anyone who'd like to learn more about common law and your grand juries, we have free weekly trainings and information on assemblies and how to participate. Again, you can find them through our website at WTPNlive.com or on our Rumble channel. We try to post one every Wednesday, but they are available, and we have a free phone number you can dial in, free to everyone in the country, both on Wednesdays and Thursday nights, 2 different calls. The Wednesday night is more local, and the Thursday night call is more of a national call. So those are listed at the website. Thank you.
Also, there is a website. There's a national effort that we're following, and it's called national-assembly.net. And that is a resource. That is a major resource, and you could go there and you can find books and articles and just about anything you need on common law. You could find the history of the Michigan group. You can find out how the Michigan Assembly actually bankrupt the 1871 corporation, because they were the ones that sent a resolution to President Trump to void the Act of 1871 because the government that owns us, the British, would not allow the people in Michigan to put on a justice of the peace that was promised in the 1871, one of the 19 items that they promised to supply us while they were waiting for us to reconvene our Continental Congress. So it's been waiting a long time, and they've screwed us along a long, long time and taken money away from us. But the biggest thing that we have to remember is that God planted his laws in our heart. He's given us 10 commandments. He's planted his laws in our heart, and we know that. And we, in our effort to return common law, it's peace, it's honor, and it's mercy. And we give mercy to those people. The biggest difference between civil law and common law is civil law comes out and thinks you're absolutely perfect, and they make statutes, they make ordinances, they make rules, because if you're not perfect, they've got a way to charge you. And in common law, we go under the preposition that we are human. We are going to make mistakes. And if we are making mistakes intentionally or unintentionally, there's a whole lot of difference. But our common law people, common law grand juries can make those decisions because they're looking at it within their heart. So that's the biggest problem, that we're governing from our heart. Doug is exactly right. If there's not a victim, there's not a crime, and the state cannot be a victim. I yield.
A return to law and justice and decency, and a return to our hearts and to God. What a perfect way to end the discussion today. Gentlemen, thank you very much for joining me. And for the Patriots out there, I hope you very much enjoyed the conversation. I'll be back with all of you again soon on the Q News Patriot channel. Thanks, everyone.
Thank
God
you
bless.
again, SG.
Yeah.
God bless you.
God bless you.